Committee on General Laws will come to order. We'll begin a subcommittee, and as soon as we get a fourth member in here, we will take roll. We only have one bill to hear today. That's House Bill number 918. Representative, when you're ready, please proceed.
Thank you, Mr. Chair, members of the committee, hearing at this late date, appreciate it, thank you. John Black, House District 129, Marshfield is my hometown. House Bill number 918 would prevent a designer or patent holder of a product from being responsible forever, basically, for generic copies of the product after the product goes generic, manufactured by somebody else. This basically just restates the law of Missouri. It would keep Missouri from following a trend, not a trend, a two-state trend, California and Massachusetts, that have got around the general rule to try to get back to the deep pocket of the original patent holder. We worked with the ranking member of the committee and the chair to make sure that the original patent holder would still be responsible for things the original patent holder should be responsible for. Came out of committee 10-0. Be happy to answer any questions. 9-0.
Thank you for that presentation. Any questions for bill sponsor?
Fire away one.
Proceed.
Just clarification. Just for clarification, I understand. So let's say I come up with like the newest, latest, greatest widget, so to speak. My patent lasts for, is it 20 or 25 years? Is it 20?
Yes, sir.
I think. So then at the end of 20 years, someone else starts making the same widget, but maybe lesser quality parts. It breaks. The person that's using said widget that is a generic widget is trying to, I guess, sometimes sue the original patent holder. Is that what we're trying to prevent?
Right. Somebody would get hurt as a result of the generic product. Certainly the generic manufacturer can and should be sued if there's something defective. This would keep the injured party from going back against the original patent holder, even though they had nothing to do with the generic product.
Perfect. Thank you.
Yes, sir.
We will pause and take roll here for just a moment. So, Madam Secretary, please call the roll.
Senators Trent,
Here.
Gregory, Bernsketter, Carter, Coleman, McCreary, Weber.
All right, excellent. We have a quorum. Further questions for the bill sponsor from the committee? Seeing none. First witness in support. Make sure you fill out witness card and proceed when ready.
Mr. Chairman, members of the committee, Jorgen Schlemmer on behalf of American Tort Reform Association. Senator Gregory, you hit it exactly correct, and that is the company that is going to compete now against the original patent holder is gaining revenue from the market share, yet not sharing in the liability. This makes sure that everybody takes on their part of their liability. That's it.
Questions for the witness? Seeing none. Further witnesses in support?
Members of the committee, Rich Albish on behalf of the Missouri Civil Justice Reform Coalition. This particular situation really only applies in situations where there's generic drugs, because there's an FDA label that approves what that drug might be. So we're not getting into every single product that's out there, because then they wouldn't have generics if that product could just be a product.
Questions for this witness? Seeing one, proceed.
Where else do you have this language? What other bills?
None. This is the only carrier.
Do you have good plans for it?
Pardon?
Do you have good plans for it?
There's always good plans for bills.
Thank you.
Further questions?
Is there any examples of this happening?
There have been in other states where this particular type of issue has come up, Missouri has rejected that in case law, and we are simply codifying the case law.
Further questions for the witness? Seeing none. Thank you for being here. Next witness in support.
Matthew Smith, Associated Industries of Missouri. Just want to go on record in support of this bill.
Questions for the witness? Seeing none. Thank you for being here. Next witness in support.
Mr. Chairman, members of the committee, Brian Bernskater here on behalf of the Missouri Organization of Defense Lawyers want to register our support for the same reasons that have been articulated previously.
Questions for this witness? Seeing none.
Thank you.
Next witness in support.
Mr. Chair, members of the committee, Luke Reed on behalf of the Missouri Chamber of Commerce and Industry, here to go on the record in support of House Bill 918.
Questions for this witness? Seeing none. Thank you for being here. Next witness in support. Seeing none. Next witness in opposition.
Good morning, committee members. Brian Madden here on behalf of MATA.
Would you make sure that your microphone is turned on? If it's not, or maybe move it a little bit closer.
Maybe
Having trouble
closer.
hearing you.
Morning, Brian Madden here on behalf of MATA. I'm an attorney in Kansas City, grew up in Lexington, Missouri. I've had the privilege of representing rural counties in Missouri, counties including Buchanan, Cass, Lafayette, Livingston, and Nottoway counties in the opioid epidemic. And this bill would prevent what we've been able to accomplish in the opioid epidemic litigation. Let me give you a real-life example. Company A makes a fentanyl lollipop called Actique. That lollipop is a branded drug. It's indicated only for end-of-life cancer pain. However, the company convinces its sales force to market it illegally for any kinds of pain, hence leading to the opioid epidemic, because doctors start marketing this end-of-life cancer pain lollipop for all kinds of pain, headaches, toothaches, you name it. People become addicted, and the opioid epidemic starts in about 2019. The public picks up the cost of that epidemic, great cost, and social services and families torn apart. That company then tweaks the molecule in the lollipop and creates a new fentanyl drug called Fentora and lets the lollipop go generic. So the branded drug is now Fentora. The sales force which illegally marketed that drug is now generic, and the fuse is lit. That generic is cheap. That company is profiting from that generic, and the opioid epidemic continues. That's what this bill is designed to do, is to shield that company from lighting the fire that it lit with its sales force, causing a public nuisance. That's what this bill is designed to do. Now, here's what we've been able to accomplish for your constituents. The state of Missouri, and these are minimum numbers because more settlements are coming in, from the opioid epidemic, for the manufacturers and distributors, including generic makers and sellers, we've recovered $471 million for the state of Missouri. I'm sorry, $275 million for the state of Missouri. For the counties that we've represented, St. Louis County, $22 million. Boone County, $1.47 million. Camden County, $1.1 million. Jasper County, $476,000. Jefferson County, $6.8 million. Lafayette County, where I grew up, $519,000. Webster County, $867,000. Those are real dollars flowing to those counties and to the state to fight the opioid epidemic that this bill would stop. And we've had a real impact. The opioid epidemic started in about 2019. Deaths from overdoses went from 70,000 a year to 115,000 a year.
Can I
In
interrupt
20
you real quickly and just ask a question about that?
Yes.
There was testimony earlier that this was codified into case law, that we're just codifying that. You're suggesting that, no, that's not the case. What specifically in the bill
Well,
isn't being codified?
I think the case law goes to product liability law. And product liability law requires but-for causation. So in other words, you have to be the product maker or seller to be held liable. This is, what I'm talking about is different. This is
Right, that's why I'm asking.
This is public nuisance law. So this bill is designed to get around.
Where in the proposed language does it do that? Can you just give me the citation of where?
Well,
which
the
line?
example that's been given, the generic
No,
make.
no, I'm sorry. What lines in the bill are doing
Oh.
what you're saying they do? Sharon, you'll get to testify in just a minute. Let him answer.
It says that the business entity whose design is copied or otherwise used by a manufacturer shall not be subject to liability.
Okay, thank you so much.
Right. So, back to the result that we've reached in the state of Missouri. Overdose deaths in this country in 2019 were 70,000 a year. By 2023, that went up to 115,000 per year. But in 2023, with the funds that we accomplished for the state of Missouri and the subdivisions, there was a 10% reduction, and in 2024 first quarter, there was a 34% reduction in overdose deaths.
Where are you getting these numbers from?
That's from an article in NPR.
Could you submit citations for that to the committee?
Sure.
Some of the statistics
can-
you're citing don't really comport to my understanding of the history of opioid abuse in this country, but I'd be
Sure. I'd
interested
be
to
happy
see your
to hand-
citations.
Be happy to hand the committee the article with that data. So, bottom line is, these rural counties that have borne the brunt of the opioid epidemic and the public nuisance caused by illegal sales activities, which caused a public nuisance. That's what happened. That type of litigation will not be able to go forward if this bill is passed. So we oppose it.
All right, thank you for that testimony. Appreciate you indulging the committee's questions mid-testimony. Any further questions from the committee for the witness? Seeing none. Thank you for that, and appreciate your further information. Thank you. Further witnesses in opposition? Seeing none. Any witnesses here for informational purposes only? Seeing none. Any further closing comments from the bill sponsor?
Thank you, Mr. Chair. I would first point out that the language that, first of all, the opioid epidemic is a tragedy. We should all be doing what we can to prevent that. The testimony that was just given to you with regard to the question from the senator as where in the exact language in the bill is that problematic was not recited back to you in its entirety. The answer that was given to the senator's question was designed, copied, manufactured without the designer's, shall, otherwise used by the manufacturer, shall not be subject to liability. The words, without the designer's express authorization, was not recited to the committee. So we would like to point that out to the committee. Further, as indicated in House committee, we took special effort to try to make sure that no one was protected from something they should not be protected from. And that is why the language in Section 2 now says, shall not alter any provision of law, including mislabeling, fraud, deceptive merchandising practices. So that law still exists. This law does not prevent actions based on those causes. Happy to answer questions from the committee.
Thank you to the bill sponsor for those closing remarks. That will conclude the public hearing on House Bill number 918. With no further business coming forward committee, do I have a motion? I would make a motion to adjourn, and it seems like it's been eagerly seconded. All those in favor, please signify by saying aye. The ayes appear to have it. The ayes do have it. The committee is adjourned.